Good morning, Your Honor. Can you hear me?
There's a serious
Mike,
echo.
try muting. I think you have audio on for computer and the phone. Mute one and try the other. Can't hear you at all, Mike.
Can you hear me now?
With an echo.
Good morning, Mike. Do you have two devices connected?
The supervisor probably always use.
Mike, do you have more than one device connected
Okay,
to
second
this?
try, can you hear me?
Yes, perfect. Thank you.
Take it off. Is he muted?
No, they can hear him. You can't hear them now. Where is the volume? Where is it? Now we can't hear you.
Yeah, get Bob.
Am I being heard now?
Yes, you're good now.
I don't know what's the website.
Okay, Mr. Sanguinetti?
We're ready, Mike. You can go ahead. We can hear you fine.
Okay. Good morning. Inspector Michael Sanguinetti, City of Fort Lauderdale, presenting case and address. CE 19120383, property address 1217 Southwest 17th Street. Inspected this RS8 single-family residence on December 10th, 2019, regarding several complaints from neighbor, including but not limited to engine noise and fumes from large boat on trailer parked in front of property. With the complaints investigated, the property was cited for the following violations. 47-34.4.b.1. This is an RS8 zone single-family residence. There's overnight parking of boat on trailer that exceeds 21 feet in length that is being stored in the driveway at this property. 9-306 exterior maintenance. This was complied as of August 11th, 2020. Inspection report was delivered to property owner as listed on Broad County Property Appraiser on January 7th, 2020, allowing 21 days to comply for both violations. Notice of hearing, notice of violation was posted at the property on July 29th, 2020. Pre-hearing inspection on August 11th, 2020 shows violation 47-34.4.b.1 remain as depicted in the photographs. The city is requesting that the violation be brought into compliance 30 days or a fine of $50 or a fine of $50 per day thereafter. Your Honor, the respondent, Mr. Moorhead, had contacted myself and the supervisor, informing that he was not able to register, and he's asking for 180 days to comply the violation.
Okay, and what is the city's position on his request?
Let them know that we can't hear them.
We're having difficulty hearing.
Okay. It's Magistrate Flynn. Can you hear me?
Yes, better.
Yes,
We
okay.
have no objection to an extension, only because Mr. Moorhead has a permit, and I think because to move the boat, he has to put the boat behind his house on the dock, and he has a permit, and I guess he just needs to do the work before he puts the boat behind the house. So we have no objections to an extension, a further
Okay.
extension.
All right, 180-day extension is granted unless anyone else wants to chime in.
I think that's the reason my client is here. He's the neighbor. And before that extension is granted, I think it's, he's taken a lot of time to prepare for this and has submitted a record. And it's pretty important to him. And so if we could just have him speak on that, that would be appreciated.
Sure.
Thank you. Mr. Brown.
Yes, can you hear me?
I can hear you fine, Mr. Brown. Can you hear me?
Yes, thank you. Your Magistrate, I'm here to testify, and Sheila Pond is here to testify. She lives here with me. I disagree strongly with an extension. Firstly, the only awnings that were painted or cleaned up were the two front awnings in front of the house. The side awnings may have been pressure cleaned, but they're not clean. The dock permit is 2.5 years old. The contractor doesn't have the facility to put this dock in. There is no dock there now. This has been ongoing since 2005. These boats and the 30-foot boat and a 36-foot trailer have been at this location for 5.5 years. These engines are run on a monthly basis, 10 feet from my bedroom window, filling my house with smoke, carbon monoxide, fumes, noise. The city has delayed any action on this for quite some time based on these building permits. These building permits cannot go forward because the plans are substandard. I've submitted an addendum to my testimony, my written testimony, showing that my professional engineer reviewed these plans in depth and in fact showed that they are deficient. The contractor doesn't have the means of building this a set of docks, and it's impossible for anyone to put anything behind this house because the neighbor on the east side of Ron Moorhead's house also constructed a fence preventing Mr. Moorhead from using his property for the same purposes. I constructed a fence in 2018, and immediately Mr. Moorhead started retaliation against me and using the city as a weapon. I filed one complaint with the City of Fort Lauderdale in the 37 years that I've lived at this address. Mr. Moorhead has filed 8 complaints against me, none of which has a complaint form. I was required to sign a complaint form before the city would do anything about this. This has been an ongoing problem for many years. Negotiating with Mr. Moorhead is impossible because of his vulgar language, his obscene comments, his attempts to intimidate and harass me are ongoing. And I'm very concerned for our health and for public safety. You can see that this blue bus that you're looking at here is a 1-ton Ford E350 van that's capable of transporting more than 10 people by the city's own definition. This vehicle, according to the city, any vehicle, section 47-34.4, section D, as in Delta, states any bus, which is any motor vehicle originally designed for transportation of 10 people, or more is in fact a bus. With
Special
this-
Magistrate, if I may, and I apologize, sir, Rhonda Montoya Hassan from the City Attorney's Office. Respectfully, we're not here with regard to an alleged bus. That complaint has already been reviewed by the city and has found to be unfounded and is not before the magistrate at this particular hearing.
I'd like to continue if I can. I realize you're not considering this. All we need is the boat removed, and the van to be parked at the north end of the driveway. This has caused an accident, not caused, but contributed to an accident that happened in my driveway. It's extremely difficult for us to get out of our driveway onto Southwest 17th Street. We've had near misses multiple times, and Sheila Pond would like to testify to that fact as well.
Your Honor, again, if I could, the status of the vehicle is not before your honor, and we have a lot of hearings today under challenging circumstances, and I would suggest that we try to stick to the violations that are properly before the magistrate this morning.
Sir, this is Magistrate Flynn. You understand I can only rule upon things that are in front of me today, so I can't discuss the van with you. I also.
Yeah, I think,
Well, no, I'm speaking, sir.
sorry, I apologize. Go ahead.
I also cannot get into whether or not the plans for the dock are appropriate. That's not before me today. What I do have some concern, and I don't understand why that there are fumes getting into your house from this. I mean, how does that happen? Does he turn on the boat every so often, or how is that happening? Is that from the van? Or the boat?
Since 2005, Mr. Moorhead has run two 250 horsepower Yamaha engines 10 feet from my bedroom window. We constantly, none of the pictures that are being shown to you have anything to do with the situation. There's a satellite photograph of the evidence I presented to the court showing that these engines are 10 feet from my bedroom window. We've tried to work with Mr. Moorhead and tried to schedule a time that's appropriate, but time and time again, he runs these engines on a monthly basis, and the noise and the fumes and the carbon monoxide fill my house and is a danger to me and my family.
Good morning, everyone. Magistrate is Portia Williams, Co-Compliance Manager for the city. I do believe that the request for 180 days is far too long. I think that we would be actually requesting 60 days as an extension in order to reappear. This case has been open since December. We're now in August. And so from my perspective, Your Honor, I believe that there's been ample time for there to be a lot more progress if permitting is the issue. The building department, we are open for permit intake. And so I would respectfully request 60 days of it for an extension versus 180 days.
And if I could say something too, again, I represent Mr. Brown. I think the main point of dispute at this point is just whether what extension is appropriate. And I want to remind the magistrate that this matter has been set for hearing now since I think February for quite some time. And so there's been plenty of time already. And
December the 9th.
And as Mr. Brown testified, this has been going on for years. And the boat has caused many issues. The driveway is not large enough, so there's that vehicle they pointed out sticks into right next to the right of way, so it kind of blocks my client's access to the roadway and being able to see cars coming. There's multiple issues here. So I mean, we would insist on the initial recommendation of 30 days to kind of remain. That allows for ample time to address the situation. And if you can't get the permit extended, or if you can't get the dock fixed in time, that's really not the city's issue. It's not my client's issue. He should be able to put the boat elsewhere. It's just not allowed to be where it is. So it's just not something that the city should be accommodating. If he needs to put it somewhere, it needs to be somewhere that's allowed, like a storage yard or like a marina, not in a driveway. So 30 days is really appropriate here. Any more than that is not supported.
Okay, anyone else? All right, I'm
I'm
gonna,
sorry, the property owner is trying to speak, but he's on mute. Mr. Moorhead, your microphone is still muted.
Okay, may I speak?
Sure, sir.
Okay. First of all, I haven't lived here since 2005. I moved in this house in 2013. Second of all, I haven't run my boat probably for 6-8 months because everything I do in my house is an issue. John complains about everything I do. As far as the boat dock goes and the seawall and everything goes, I have all the appropriate permits. I have all the appropriate engineers. I have all the appropriate contractors. John has called his attorney to challenge my plans, the city, everybody else, and it has kind of put a halt to this whole thing. Otherwise, it probably would have already been done. So the issue is not me. The issue is that the police have been here several times. They've seen my van. They say it's not an issue. City of Fort Lauderdale code has been here several times. They say, hey, that boat's been there for 7 years. It's never been an issue until your neighbor complained. All these things are brought on because John Brown is unreasonable. And as far as me saying anything to him or whatever, I don't even speak to the guy. So he's made it very difficult for me. He actually put a fence in, the fence that he's talking about that he put in, and then sent me a letter from an attorney saying that I was trespassing because the fence was 2 inches on his property and the property on my side of the fence was actually belonging to him. How ridiculous that is, I can't even tell you. He's the one that put the fence in. So the guy is out of control. I don't know how to handle all this. I have all my permits in place. The city has approved everything I have submitted to them. Everything's been submitted. The permit is in place. He's out there harassing the guys when they are here to do the job. And it's cost me the time because, you know, he's affected the job because he's out there harassing the guys when they're here. He sent my plans to an attorney that said that they're not right and they're all approved.
Magistrate Flynn, I'm speaking. Okay, I understand, but I can't deal with all the neighborhood squabbles and how I have to deal with what's in front of me, okay? And what's in front of me is the boat. I can't deal with the permitting issues. I can't deal with all of that. I can't deal with the van. I have to deal with what's in front of me. I don't have any other recourse. So at this point, I'm going to grant 42 days and a notice to reappear. And so we can check on your progress. And in that time, I would request that you do not run that boat so that there are any fumes getting to the other property. Does everyone understand?
Yes, Your Magistrate, and thank you very much.
Okay,
This is John Brown.
all right, thank you. Did we have a fine with that or just an extension? Just $50. $50, okay, or $50 a day thereafter. Okay, next case, please.
Our next 3 cases are on page 1, 2, and page 1 and 2. Case number CE 1808198, case address 3300 Davie Boulevard. Owner Soraya Holdings II Inc., Inspector Manny Garcia. Property posted 7/31/2020, posted at City Hall 8/7/2020. On page 2, case number CE 190200960. Case address 3200 Davie Boulevard, owner Soraya Holdings II Inc., Inspector Manny Garcia, property posted 8/3/2020, posted at City Hall 8/7/2020. And also on page 2, case number CE 180711161, case address 3204 Davie Boulevard, owner Soraya Holdings II Inc., Inspector Manny Garcia, property posted 8/3/2020, posted at City Hall 8/7/2020. Everybody's here?
Good morning, Your Honor. I'm Carly Quigley, attorney representing the property owner in this matter.
Carly, can you hold on 1 second? The inspector typically goes first, and I can tell he's speaking. They're just having some sound issues. Okay?
Thank you.
May you unmute the microphone?
He's for.
There's, I don't see a Frank
Inspector?
Sarvia.
Inspector?
It's Manny, you need to.
Danny, unmute the microphone. There we go.
Can you hear me now? Okay.
You asked him to mute one of his devices.
Manny, you have to mute one of your devices.
Okay, can you hear me now?
Okay, I need to swear you in. Can you raise your right hand, please? Carly, Manny, correct? Eric,
Yes.
do you solemnly swear to speak the truth at today's hearing?
Yes.
Yes.
Thank you.
I can't hear them. Okay. For the record, Manny Garcia, City of Fort Lauderdale Code Compliance Inspector, presenting case CE 18081968 for property located at 3300 Davie Boulevard. Originally, Inspector James Fetter inspected the property on August 25th of 2018 and cited for the following violations. 47-20.20.h, the parking areas of this property are not being maintained. There are potholes in parking surfaces. There's neglect in the maintenance of striping, wheel stops, and resealing. The landscape areas are not being maintained appropriately. 47-21.11.a, the landscaping on this property is not being maintained. There are areas of overgrowth and dead and missing plants, as well as various invasive plants on the property. There are overgrown hedges in the parking area that are not being maintained. There are bare areas with missing ground cover, and the current landscaping is not in compliance with the original landscape plan. 47-20.13.d is complied. On August 12th, a re-inspection was performed and observed that the property remains in violation. Notice to appear was posted at the property on August 3rd of 2020. The city at this time is requesting 63 days to repair all violations. If not in compliance, the city requests to impose a fine of $100 per day per violation until violation has been cured.
Is that on all three cases, Manny?
I can read all the cases if you'd like me to.
Yes, please.
Yes, please.
Okay. So for case CE 19020960, property is 3200 Davie Boulevard. Senior Inspector Wilson Quintero inspected the property on February 12th of 2019 and cited for the following violations. 18-12A has been complied. 47-19.4.D.8 has been complied. 47-20.20.H, the parking areas of this property are not being maintained. There are potholes in the parking surfaces. There is neglect in the maintenance of striping, wheel stops, and resealing, and the landscape areas are not being maintained appropriately. 47-21.11.A, the landscaping on this property is not being maintained. There are areas of overgrowth and dead or missing plants, as well as various invasive plants on the property. There are overgrown hedges in the parking area that are not being maintained. There are bare areas with missing ground cover, and the current landscaping is not in compliance with the original landscape plan. 9-306 has been complied. On August 12th, a re-inspection was performed and observed that the property remains in violation as per depicted on the photos. Notice to appear was posted on the property on August 3rd, 2020, and the city is requesting 63 days to repair the violations. If not in compliance, the city requests to impose a fine of $100 per day per violation until violation has been cured.
last case?
CE 1807-1161. Property is 3204 Davie Boulevard. Inspector James Fetter first inspected the property on July 14, 2018, and cited for the following violations. 9-306 has been complied. 47-19.5.E.7 has been complied. 47-20.13D has been complied. 47-20.20.H. The parking areas of this property are not being maintained. There are potholes in parking surfaces. There is neglect in the maintenance of striping, wheel stops, and resealing, and the landscape areas are not being maintained appropriately. 47-21.11A, the landscaping on this property is not being maintained. There are areas of overgrowth and dead or missing plants, as well as various invasive plants on the property. There are overgrown hedges in the parking area that are not being maintained. There are bare areas with missing ground cover. The current landscaping is not in compliance with the original landscape plan. On August 12, a re-inspection was performed and observed that the property remains in violation as depicted in the photos. Notice to appear was posted on the property on August 3rd of 2020, and the city is requesting 63 days to repair the violations. If not in compliance, the city requests to impose a fine of $100 per day per violation until all violations have been cured.
Okay, counsel for the property owner, is your client in agreement to bring the property into compliance within 63 days?
Your Honor, if I may, he is absolutely in agreement with bringing the property in compliance, and this has been an ongoing undertaking for some time now. He had to engage an arborist as the property, which is named Twin Oaks Plaza. Its namesake, it has, I think, over 70 some oak trees on the property, and this is what initially caused the issue here, as these oak trees had basically overgrown the space in which they were originally planted, these islands. So he engaged an arborist to conduct a study per the city's request, and ultimately has identified which oak trees need to be removed because they are just continuing to cause violations for the property. The roots are causing an issue. So he did that. He then got a landscape architect on board, and over the past, throughout the entire 2019, we spent, I think, no less than 6 in-person meetings with city officials. I know Rhonda was in some of those. Dick Eaton was largely involved. I know he's no longer there. But it was a major undertaking ultimately to arrive at a landscape plan that would revamp the entire plaza, including removing over 50 of these oak trees. So he has committed to this plan. We just got permitting issued on Monday of this week to proceed with the plan. We actually have our contractor here, Brett DeCapito, who's on the hearing as well, to speak to the time and undertaking it will take to do this work. So he is absolutely committed to bringing the property in compliance. The issue is quite simply the time it will take to do that, Your Honor. And with that,
what time are you asking for, counsel?
Sure, Your Honor, we're asking for 150 days, and the reason is because this is not just a matter of, trees to bring it in compliance with the original landscape plan. This is an entire revamping of the plaza. We have to remove the trees that, and my client just, placed a check to the tree trust fund earlier this week to the tune of $50,000. We need to remove those trees. I will turn it over to the contractor to speak to the exact timing, but every bit.
Counsel, does the city have any objection to 154 days?
Yes, Your Honor. Portia Williams, co-compliance manager for the city. This case has been going on since really before February of last year, over a year later. The violations, in my opinion, are very simple to remedy. It's landscaping in a parking lot. Landscapers are working even during the pandemic. I'm not opposed to a long term of 180 days, but I believe that we should start out with shorter increments and require updates. So possibly starting between 30 and 42 days for this first extension, and then going from there, just so that we can see some progress, because plainly put, it's been more lip service than action, in my opinion, Your Honor.
Okay, counsel, will your client agree to 63 days and a notice to reappear?
Yes, Your Honor, but if I may just add one thing, sure. In preparation for this hearing, we submitted over 300 pages of evidentiary support for for back and forth. literally-
Council, we can't hear you real well.
Sorry, I don't, is this any better? Any better now? I'm not sure what the issue would be.
Yeah, I can hear you now.
Okay, I apologize. I just wanted to be clear, this truly was not lip service, Your Honor. I mean, we have been on a weekly basis, like I said, I submitted over 300 pages of emails back and forth, the email chain. This was extensive undertaking on time and effort collectively with the city, and not just, you know, my client, but to truly revamp this and get a permanent fix for the shopping plaza. So that is really, truly the issue. And also to keep in mind, please, that we have an active tenant on the property. Our anchor tenant is a grocery store, and they are an essential service. They are operating right now. And so the work needs to be done in conjunction with, you know, working around their schedule, because we, you know, it is a major undertaking. Again, we have the contractor here. If you'd like to hear from him, he can give a better detail as to how we plan to use the time, because we will need every minute of it. So that's what I would say.
Okay, all right. I'll hear from the contractor briefly then.
Thank you, Your Honor. Brett.
Brett?
Yeah, there's a lot of work to do out there. We've probably got, there's 60 oak trees to remove. That work will take approximately 4 weeks. There is about $170,000 of landscaping we're putting in, and that work will take approximately 6 weeks. And it's hard to put a firm date on that work because, like Carly said, we're going to be working around in a Winn-Dixie that's in operation. So I don't know if that gives you enough detail, but there's a lot going on out there, and it's not just a touch-up. These guys are revamping that entire plaza. It's going to look beautiful.
So how long do you think it will take?
I think Carly had hit it right on the head with 150 days. I think I can get mine done in 120 and then 30 days for the parking lot work. You want to get all this landscaping done before we tackle the parking lot, or we'll rip it up when we do our work.
Okay. All right, I'm going to grant 98 days and a notice to reappear if it's not done within that time. And a $100 fine after that if it's not, if you, so if you come up to that deadline and you're still got work to do, contact the inspector and request an additional extension. Okay.
Can't speak for Carly, but okay with me.
Thank you. Next hearing.
Next case is on page 3. Case number CE 200300611. Case address 739 Northwest 2nd Avenue. Owner Raymond Rapaglia and Tracy Castillo. Inspector Roberta Jones, Supervisor Bass presenting. Property posted 7/30/2020, posted at City Hall 8/7/2020. Additionally, on page 3 is case number CE 20020274. Case address 741 Northwest 2nd Avenue. Owner Raymond Rapaglia and Tracy Castillo. Property posted 7/30/2020, posted at City Hall 8/7/2020. Supervisor Stephanie Bass presenting. That's what it is.
Stephanie, please raise your right hand. Do you solemnly swear and affirm to speak the truth at today's hearing?
Yes, I do. Can you hear me?
I can. Thank you, Stephanie.
You'll have an echo again.
Good morning, Supervisor Stephanie Bass on behalf of Roberta Jones for the City of Fort Lauderdale, presenting case CE 200300611 for the property located at 739 Northwest 2nd Avenue. The property was first inspected on March 12, 2019 under case number CE 190-30792, and the following violations were found. 47-18.4.47A. The property has been identified as a community residence and has not been registered with the city as required. This case is a continuance from the above stated case number, as the application process was not completed prior to the closing of the case. Under the current case number CE 200-30611, an inspection was completed on March the 11th, 2020, where it was found that the property remained in violation by operating as a community residence without the required approval. A print form request was submitted to schedule the property for a special magistrate hearing. The hearing was delayed due to temporary suspension of magistrate hearings. On May 18th, 2020, an email was received from Carly Ann Grant in Urban Design and Planning confirming that the approval process to operate as a community residence had not been completed. On July 31st, 2020, the property was posted for today's virtual special magistrate hearing. A pre-hearing inspection was conducted on August 11th, 2020. It was found that the property is still being occupied as a community residence, and it was also verified with Urban Design and Planning that the approval process to operate as a community residence had not been completed. The city is requesting a finding of fact that the violation exists and 63 days for total compliance, to include a 30-day milestone with documentation showing that a DRC sign-off will be obtained within a 30-day period for approval to operate as a community of residence, or by reducing the amount of tenants to 3 or less, or finding the amount of $100 per day for each day that the violation remains.
Okay, who is appearing on behalf of the property owner? Sir?
Courtney.
Oh, where is Courtney?
Good morning, Your Honor. I apologize. I was on mute although trying to speak. Courtney Crush on behalf of the property owner. Your Honor, we would appreciate the consideration of staff's recommendation. This property, which the city has identified as needing a conditional use approval from the city's Planning and Zoning Board for community residents, has applications pending, both this property 739 and 741. I have been speaking with not only Supervisor Bass, but also Assistant Planning Director Cooper, who believes that the existing DRC comments can be responded to within 30 days back to the city. At that point, the city would agendize the community residence application in front of the Planning and Zoning Board. We are committed to meeting that milestone and would appreciate your honor's consideration of that. I've been provided the DRC comments and we'll review them with the owner. I obviously work with closely Director Cooper, and if he believes we can achieve that in 30 days, that seems like it might be sufficient. Another component of that is public participation to the neighborhood. In listening to your sign-in this morning, I believe there are some residents from the Progresso neighborhood. We have reached out to JJ Hankerson, who is the president of the neighborhood, to request a public presentation, which again is part of the conditional use approval in front of the Planning and Zoning Board. I know the past president, who has passed away, Ron Centimore, was also coordinating with the property. I didn't clearly hear who was also on the call this morning, but that's a component also. I also want to point out, Your Honor, there was a third property directly across the street, 736 Northwest 2nd Avenue. That property was identified in the code citations at the same time. That property had activity that included meetings for AA and the St. James Club does wonderful work. And in this case, providing community residents, not supervised, not a halfway house, and is going through the right process. But that property, the decision was made by the owner, given the complaints on the street, to vacate that property. That was done effective April 1st. My understanding in speaking with Portia and Supervisor Bass is there have not been complaints to the city since that April 1st deadline. So I have a comfort level as we continue through the process, if your honor will consider the appropriate time to allow us to go to the public hearing, that we can both engage the neighborhood and also achieve the deadline that Supervisor Bass has indicated.
Okay. And is there anyone else from the neighborhood here to speak?
Yes.
Yes, there's three of us here. I don't know if Ron and JJ would like to speak first.
Yes,
They are
would
representing the Civic Association.
Okay, have they been sworn in?
Yes.
I have been sworn in, but JJ was having technical difficulties, and you can swear him in right now. He's with me.
And I'm here as well.
JJ, please raise your right hand. Do you solemnly swear in affirm to speak the truth at today's hearing?
Yes.
Okay, go ahead. Thank you.
Yeah.
My name is JJ Hankerson, and
Hang on 1 second. Has to be off. Yeah. Because we're getting.
My name is JJ Hankerson. Are you there?
Yes, you're fine. It's Mara that has to mute.
Mara's muted.
Continue?
Yes, continue, sir.
Okay. Like I said, my name is JJ Hankerson. I am the president of the Progressive Village Civic Association, and I'm here to, I'm representing the community and would like to commend on the case that have been put forth. We've been dealing with this, the halfway homes in this community for about pretty much almost 3 years. And the community, I get steady complaints about them and what's going on. And I know that you want to talk about what's on the table. So this is what I'm going to say, because there's a lot that's going on with this, and it's you don't know about. But the thing is, we shouldn't be here now because in the ordinance, they're supposed to be 1,000 feet apart. They have 4 right among each other. They had the property that was across the street, but they closed down, and they got a property which is 736 on 3rd Avenue that's already existing now. But I know that's not on the list. But we asking, we've been having problems with it, and we already have our drug problems and the drug problem, and we want to. We don't need the James Club to come in, because it brings in a story that they want to give back to the community. But we have people. He have helped us pick up paper, but that's about it. But that wasn't necessary. The problem is that one of our family members have left because of the James Club, and we're trying to get a better. We got a lot of things going in our community that's building up our community, and we trying to get things better. So if the magistrate, if we can stick to the code law, the ordinance, that they put it 1,000 feet apart, no matter what, that probably would take care of a lot of our issues if you consider that.
Okay, Ms. Crush, do you understand what he means by 1,000 feet apart? And can you weigh in on that?
Certainly, Your Honor. Mr. Hankerson is, of course, correct. In this case, the city enacted in April of 2018 the residence applicable to community residents, which requires for community residents to be permitted with no entitlement process, 1,000-foot distance separation. In this case, Mr. Rapaglia owns a second duplex, which is the immediate north next door neighbor to the properties that are before Your Honor today. So his duplex to the north, which is located at 743 and 745 Northwest 2nd Avenue, is a existing licensed and approved community residence. The process to ask to have a community residence which is within 1,000 feet of another is a conditional use application in front of the in front of the city, ultimately reviewed and analyzed by the city's planning and zoning board for compatibility. So is the appropriate number of residents proposed? Are there any services provided? In this case, no. Are there, is it something that changes the character of the neighborhood? Is it something that's compatible? So while Mr. Hankerson is right, and the existing 743 and 745 is within 1,000 feet. So half of the James Club is within 1,000 feet of the other half. And again, we are right now, as I review the DRC notes, in the process of going through the conditional use process, which again is for consideration by the planning and zoning board as to whether a second community residence is appropriate within 1,000 feet. And the picture up on the screen, Your Honor, on the right is the existing licensed community residence. On the left is the second the second location. So about 10 feet, not 1,000.
Okay, are they currently operating as community residents, or did you say something about them being shut down temporarily?
What you can't see if you could, not temporarily, on the other side of the street, there was, as Mr. Hankerson indicated, a property on the other side of the street, which was holding meetings, was shut down permanently, not temporarily. My understanding from meeting with, again, Director Cooper and Director Fajardo is the city has concluded that this is a community residence. If you're asking if there are people living there, the answer is yes.
Okay. All right. Can I hear from the city attorney in terms of, the process they're going through and whether these people should be heard on this 1,000 feet issue before building, in that process or in front of me today?
Yes, Your Honor, thank you. Ronald Montoya Hassan with the City Attorney's Office. The issue, of course, before Your Honor, is just the registration process. Part of that is an ancillary proceeding, as Ms. Crush has indicated, that goes to the planning board. That's a requirement that, again, counsel for the property owner has acknowledged. They have to go through that process before they can be registered. The planning board, I understand, has the authority to consider whether or not to waive that 1,000-foot requirement. But again, I don't handle those hearings. The issue just before Your Honor today is the path towards registering as a community residence and the amount of time within which to do that. Now, certainly if the planning board doesn't grant the conditional approval, then that's obviously a different scenario that's presented to the property owner that, arguably they could not operate at the location. Because they wouldn't, and again, that gets into a lot of different issues, but they couldn't certainly register if they don't have that conditional approval.
And in that process, these homeowners will get a chance to speak their mind to the board.
Yes, ma'am. I would believe that the planning board would hear from the affected residents as to the impact on the neighborhood.
Okay, I'm going to take the city's recommendation of 63 days, 30 days for DRC sign off.
I'm sorry, do we not get to speak?
Your Honor, can I please speak before you make a decision? This is Ron Lux. I'm the Vice President of the Civic Association.
I would also like to speak.
And I would also like to speak.
Yes.
Okay, I'm sorry. I thought you indicated that one person was speaking for you all. Go ahead.
No. Okay, the reason why I want to speak is, Your Honor, first of all, this has been an ongoing situation. They have been operating illegally for years, okay, without this application and expanding this facility more and more and more, okay? I was the president of Old Progresso Village Townhomes for quite a few years before this, and I had to deal with our residences, which is right next door, okay, with multiple people hanging out in the courtyard, foul language, loud music, people hanging out in front of the halfway house, cars parked all over the grass, which they've been cited for damaging the landscape and they've had to replace. And the problem here is they've been running this for quite a few years now illegally. And yes, they did finally close the one across the street because they had pressure on them, okay? But this extension should not be granted. They shouldn't even have any time to have it granted because it's been going on for years and it should never even been allowed for this to even happen, okay? It has changed our neighborhood to a worse situation. We deal with high drug problems, prostitution, and now we have these people that are in this home that I 100 agree they deserve a chance. I said, but when it becomes a personal issue, okay, I have a son that also had drug issues, okay? And when my son comes to me and tells me that the owner of this facility is putting pressure on him because I'm on the Civic Association to allow this in my community, I'm sorry, that's where it stops, okay? It has affected me emotionally and it has affected me for my community to make it a better place to live. And this is not what's happening. It's going the opposite way. So that's what I have to say about this.
I understand and appreciate your concerns.
Thank you.
Yes, go ahead.
Good morning, Your Honor. My name is Raul Dominguez. I am the current president of the Oak Progressive Village Homeowners Association. That is about 34 townhomes on 1st and on 2nd Avenue. 2 of our units are next door to these halfway homes. And I do have to second what Ron has stated here. It is clear that there's a violation of the code or some type of loophole that might be getting exploited here. They have not been approved, but they are operating in a very densely populated manner. If you just drive by that street, you'll see a lot of cars, you see a lot of people, you see a lot of movement at all times. I have had friends and family and folks who have been interested in moving into this community and potentially purchasing properties or renting. And when they find out what's happening on 2nd, it basically discourages people to invest into our community. And a lot of the homeowners and a lot of people that have lived here are really excited about a lot of the positive change that has been coming to us. And a lot of us have been working very hard to make this community a better place to live. And although people need facilities to help them recover from drug problems, it shouldn't be near downtown Fort Lauderdale. We have drug dealers that walk our streets all the time. My car has been broken into in the last 2 years, probably 12 times. I see drug deals happening on 8th and Andrews, just a block away from where this facility has been expanding and growing. This is not the place. This is not the place. This is a community that's suffering from drug problems. You do not build halfway homes in a community that's been suffering and recovering from drug problems.
Sir, I really appreciate what you're saying and I sympathize with all of you. But the only thing that I'm allowed to do today is discuss the registration. I can't decide whether the registration is ultimately granted or they're allowed there. I can only deal with what's in front of me. Ms. Crush, do you want to have a word on what?
I still didn't get to speak either.
Oh, I'm sorry. I don't see everybody on there. So
I know, it's okay, it's okay. Do you want me to go?
I'll let you speak, Mara, and then I'm going to ask the attorneys to weigh in before I rule.
Okay. I have a transcript that a couple of the people from the community wrote. I'll try to cut it down. It says, we already have quite a few transitional community residences in our neighborhood, and all are well within the 1,000 feet as required in section 47 to 18.47 of the ULDC. We have been tolerant of these residences and brought our concerns up with Ray Rapaglia. The neighborhood is not conducive environment for those individuals who may be looking for a path of recovery from these social pressures of their past. On July 15th, where Ray was invited to speak about his organization, sorry, he was questioned about the potential growth of his business, and he said he's not looking to grow and wants to downsize in the community. I can tell you now that I live at 742 Northwest 3rd. He just bought the property next door, 736 Northwest 3rd, and all three of them are halfway homes. I can see from my backyard, there are 2 bunk beds in 1 room. So that means there's 4 people living in a room. He has people over here on the 736. So they're on all sides of me. They jump my fence. I've seen a lot of drug dealers and prostitution in the neighborhood. Like we said, they are not operating within the 1,000 feet. And I don't think they should be granted the 63 days. The longest amount of time, I don't think they deserve any time, but maybe 5 or 10 days. They like Ron said, they have been operating illegally for years. And they try to intimidate anyone in the neighborhood who doesn't want to see them prosper. But this is where we live, and we want to have a nice community. And they keep bringing in more people that have quick access to all the drugs and everything around here. You know, we're trying to clean it up, and then he brings them around and there's more drug deals going on. And then when we say something, he tries to intimidate us, you know, with the people walking around. It's not a comfortable situation, and we don't want any more halfway houses in our neighborhood.
We request, Your Honor, that you do not grant an extension.
Okay, I heard you. Ms. Crush, and then the city attorney briefly.
Your Honor, Courtney Crush, again, we will commit to sit with the neighbors who are on the call as soon as convenient for them. The citation for again, this is a new ordinance. If there are other than Ray's community residences in the neighborhood, they may be similarly grandfathered in. In this case, since these cases were brought forward, what I understand to be the more intense or objectionable activity has been removed. We would very much like to sit with the neighbors so that we can have a discussion about what is appropriate as part of the certification process, which is what the code citation advises is required under the code, can proceed forward for consideration as quickly as possible with the input of the neighborhood.
He already sat with us last year.
Yeah, and if you'd give me the opportunity, I'd very much like to sit with you. Certainly understand comments about compatibility and safe behavior, et cetera.
The thing is, you don't live in our community.
Understood.
Okay. Unfortunately, I can't conduct that meeting here. I'll give the city attorney the last word before I rule.
Thank you, Your Honor. And just for edification for the neighbors' sake, this is a new case. So this is not an extension of time. This is a new case. The statute requires in magistrate proceedings that the magistrate provide a reasonable time to comply. So again, this is not a new case, and it would not be reasonable under the circumstances to give a compliance deadline of 5 or 10 days.
Why? He's been running illegal.
Sir, I'm speaking based upon what is being presented. What is being presented to the magistrate is only the registration process. The issue for the neighborhood impact, which goes to the conditional approval, is not before the magistrate. That is an issue for the planning board. Any police issues, drugs, prostitution, the police should be called on those issues. Issues with cars parked everywhere or trash or any other sort of municipal code impact to the neighbors, obviously can be called in to code enforcement. But our issue today before the magistrate is solely the lack of registration for this community residence and what is a reasonable time frame to comply with the requirements of the code as a new case.
Okay.
Thank you, Your Honor.
All right, thank you very much. 63 days and 30 days for the DRC to sign off, or the residents get reduced to 3 persons.
Your Honor.
Or $100 fine per day after that.
Yes.
Thank you. Next case.
Our next case is on page 4. Inspector Will Snyder. Case number CE 19100069, case address 625 Coral Way. Owner Thomas A. Valerio. Case first heard 2/6/2020 to comply by 3/12/2020. One section not complied at $150 per day. $22,950 accrued, and this is a request for an extension.
Can I briefly just ask, is the last hearing is for both cases, 739 and 741? Because it was 2 separate cases.
Yes, Inspector.
Okay, thank you.
Hello.
Will, please raise your right hand. Do you solemnly swear in affirm to speak the truth at today's hearing?
Yes.
Thank you. Go ahead, Will.
Oh, did they have to do a present? What? Oh, for which one? Which
We're
case?
just here on the motion for extension, right?
Request for an extension.
That's right.
Yeah. Okay, yeah, we had requested an extension before the initial deadline.
Just a second. I need the case read in and the inspectors.
Oh, okay. I wasn't sure if that same process happens with these. Okay,
Yeah, just so that we have the record straight what case we're talking about.
sure. Thank you.
You're
Okay,
welcome.
Code Officer Snyder, Fort Lauderdale's Community Enhancement, presenting case CE 19100069 for the property located at 625 Coral Way. This case was first heard February 6, 2020. The magistrate ruled in favor of the city, and the property owner was ordered to correct the violations at the property by March 12, 2020. At this time, one violation remains, and the city is requesting full imposition of fines.
Will, do you want to state what violation remains, please? For the record?
Violation that remains is for a dock in disrepair. However, it's not the only violation at the property. I believe previously that we had a pool with a pool maintenance violation that was withdrawn from this case, I guess due to a lack of photo evidence. There's also cases being monitored by our building division regarding expired permits. And I've also witnessed and taken photos of evidence what seems to suggest that the balcony at this property is a life safety hazard.
Okay, but the only, hold on. The only case before the magistrate today is one component, the dock and disrepair, correct?
Yes.
Yes.
Right, I understand. I just wanted to give some background about this property and why the city is requesting full imposition of fines.
Okay, thank you.
Okay, sir.
Thank you. Ryan Abrams, I'm the attorney for the property owner, Thomas Valerio. So I would submit respectfully that there's no authority to impose fines at today's hearing. That was not the notice. That was not the purpose of today's hearing. The only purpose of today's hearing is to address the request for extension. So just want to put that out there. But we did submit a request for extension. It was submitted before the deadline. So that's why today, if imposition of fines would be inappropriate, I would submit. Anyways, there has been the property owner is working on the situation. There has admittedly been delay, and I'll admit it has been a little frustrating for me. He is a busy person. It's not his primary residence. I have successfully lobbied him and his team to finally appoint somebody to deal with this property and to be overseer of the property. It is a contractor. William, or the inspector, I believe, spoke with him. His name is Ali Razai. He's a reputable contractor, a friend of mine actually, and he's gonna focus on the issues daily at this point. He's on top of the dock issue. I believe the inspector spoke with Mr. Razai yesterday, and he's going to have his team on it and deal with the dock issue. It wasn't immediately clear to him what was wrong with the dock, but he is addressing it. So I just want to let the magistrate know we are working to address it, and another 30 days would allow us to address the issue, I believe.
Okay, I don't understand why nothing's been done from the last extension.
There was and we never an opportunity to address the issue, but address the request for extension in the first place. This is the first time we've had to address the extension request. But I don't have a good answer for you, to be quite honest. I don't have a good answer. All I can say is that I have finally been able to get somebody retained by the client and by the property owner, a contractor by the name of Ali Razai, who's spoken with the inspector yesterday, and I have been assured that it will be addressed, and I just need 30 days, please, to address the issue. And then we can, but again, we still need to discuss the fines on a different occasion, not today, is what I would say.
Your Honor, if I may.
Go ahead, Rhonda.
Thank you. Rhonda Montoya Hassan with the City Attorney's Office for the record. Your Honor, if I could suggest, because as the inspector stated, the case was heard in February for compliance a month later in March. Now we're in the middle of August. And I agree also with counsel that it is correct that we cannot consider fines today because it was not so noticed. Based upon, it would be the city attorney's position that based upon what counsel said, there's not really a basis to grant an extension. They've already had a de facto extension, for months from February to August. And if Your Honor would consider denying the extension and scheduling it for a Massey, in essence, they will have their extension in any event, and maybe the case will be in compliance by that time.
Okay. Counsel, do you understand what she's asking for? If I deny the extension today and we schedule it for a Massey hearing, it's probably not going to get on the docket for 30 days. So you'll essentially have your extension and you'll have to address the fines at a later date at that hearing.
Okay, here's my comment on that, and I appreciate what Rhonda's trying to do there, because I understand. Like I'm trying to be transparent about why I'm here today, and I'm honestly trying to help out. But if that were the case, if we're just going to schedule this for the Massey hearing, that means that we're going to be found in violation, either way, and that we're going to go fines potentially from March to today. That's the situation we'll be in. So the request for extension is really, at least it's important, at least to a certain date, because if not, we're going to be hit with fines at the, so the deadline, as the inspector said, was in like March. And so we're like 5 months past that. And again, my request for extension was never heard until now. So it would be inappropriate, I think, to impose fines retroactively from March to today. So that's what I would say. I think it is fair to at least give me some kind of an extension, to give me some kind of leeway to work this out with the client. Again, I've convinced the client to give me retainer to hire a contractor. The inspector spoke with the contractor yesterday. I'm trying to show some good faith here. It's frustrating to me that it's taken that long, and I agree with you. But if you're not going to give me 30 days, at least give me something I'm asking for, so I can tell my client, hey, we're avoiding fines, but I need your help here, 15 days or whatever, just something that I could say, we need to get this done, guys. But if we're going to get hit with fines, it's like all this is for nothing that I've done, Just asking for a little bit of help here.
I understand your position. I'm also cognizant of the fact that, we're in strange times, but the fact is that the first hearing was in February to comply by March, and due to the circumstances, they've gotten 4 additional months already, and nothing's.
Yeah, sorry. Go ahead. I apologize.
So I appreciate, you know, I don't think your client is really showing very much due diligence.
If I can just add one thing, I think there has been 4 months and counsel for the city said it's a de facto extension, but that's not true. It's still like, if we don't get any kind of extension, fines can run from the original date in March.
All
So
right,
it's not a de facto extension.
All right, I'm going to give you 14 days extension, and the fines will be suspended during those 14 days, and then they will continue to run. And you tell your client, I'm done with this stuff. He's got to show
Yes.
some diligence.
Absolutely.
All
Okay.
right, thank you very much, counsel.
Thank you.
Bye.
I'll leave with them. Thank you, Your Honor.
Our next case is on page 8. Inspector Will Snyder, case number CE 20030366. Case address 624 Isle of Palms Drive, owner Stephen Saber. Property first cited 3/11/2020 to comply by 3/25/2020. One section not complied at $150 per day. $21,000 has accrued. The city is requesting full amount and fines continue to accrue. This was a citation.
Okay.
Code Officer Will Snyder, Fort Lauderdale Community Enhancement, presenting case CE 20030366 for the property located 624, excuse me, Isle of Palms. The property was first inspected on March 11th, 2020, and given 14 days to correct for the following violation. 24-11A, there is no dumpster provided for the property, which is under permitted construction. This case was brought into compliance yesterday, August 12th, 2020. The city has recommended a vacation of the accumulated fines.
Okay, sir, who's appearing on behalf of the property? Sir, do you want to speak?
Mr. Hart?
Yes, I'm here.
Okay, I'm assuming your client's in agreement to vacate the fines and you can move on, right?
Yes, ma'am.
Okay, thank you very much for appearing today, and thank you for your patience.
Thank you.
What an easy one.
I would like to submit my case evidence to the case file.
Thank you.
Take care.
Our next case is on page 7. Inspector James Williams. Case number CE 20030675. Case address 1532 Southwest Field Place, numbers 1 through 4. Owner FL Rentals LLC. Property first cited 3/16/2020 to comply by 3/18/2020. One section complied at $200 per day. $6,400 accrued, and the city is requesting full amount.
I have $800 approved.
On page 7?
Page 7.
1532.
Oh, I'm sorry. Okay, I'm ready for the inspector.
I'm here.
I'm sorry. Can you repeat the case number for me, please?
CE 20030675. 1532 Southwest Fifth Place, 1 through 4.
Gail, can you please raise your right hand so I can swear you in?
I do.
Gail.
Good morning, Your Honor. Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 20030675, address 1532 Southwest 5 Place. I inspected the property on March 16, 2020, and cited for the following violation: 24-29A. The dumpster is overflowing with trash and not being maintained. There are trash bags and trash on the ground around the dumpster. Posted a citation notice on the property. We inspected the property on April 20th, 2020, and found the following violation complied as depicted in the photos. For 24-29A, the city is requesting full amount to be imposed.
Okay, who's here for the property? I'm sorry, wait 1 second.
Sorry, Gail, I need to swear you in. Raise your right hand.
Gail, you need to swear in.
Do you solemnly swear and affirm to speak the truth at today's hearing?
Yes.
Okay, thank you, Gail.
Okay, can I hear from the property owner?
Me, I'm Marco Vieri. I'm the owner.
Can you tell me why this was such a problem for so many days?
It wasn't such a problem. There were several violations to the property. Whatever I was able to do personally, it was completed within 24 hours. If you look at the picture, the dumpster is broken. And I spoke to the garbage company. They told me that they were having difficulty lift the dumpster to empty it. And I requested for the dumpster to be replaced, which was done, unfortunately was done after they were having problem. The guy told me that they had no dumpster to replace it. I did everything I could. I had the garbage company call the inspector to notify. I know that the phone call was made. Everything I did, the best I could. Unfortunately, I got no control over the garbage company and the dumpster.
How long did it take you to replace the dumpster?
Honestly, I don't remember what that was replaced, but I want to say that it was done with probably about a week or so after the date granted for me from the inspector. And like I said, I wish I had a way to get a dumpster there myself. It's not something that I am capable or I was allowed to do. I did everything I can. There was a several phone call made for me to the garbage company, and I know that the garbage company made the inspector aware of this situation.
Okay, anything else from the inspector?
No.
Okay, all right, I'm gonna reduce the fine to $1,400. Next case.
Our next case is on page 8. Inspector Gail Williams. Case number CE 20030351. Case address 200 to 204 Southwest 2nd Street. Owner, William Burke and Alam Burke Trustees LLC. This property was cited on 3/9/2020 to comply by 3/11/2020. One section complied at $250 per day, $3,000 accrued, and the city is requesting full amount.
Good morning, Inspector Gail Williams for the City of Fort Lauderdale, presenting case CE 200-30351, address 200 through 204 Southwest 2th Street. I inspected the property on March 9th, 2020, and cited for the following violation. 18-1, dumpster doors open, trash, debris, garbage bags, and boxes. At 204 Southwest 2nd Street, there are black garbage bags and broken chairs at 200 Southwest 2th Street. Posted a citation notice on the property, re-inspected the property on March 24th, 2020, and found the following violation complied as depicted in the photos. 18-1. The city is requesting full amount to be imposed.
Okay, property owner, please.
Hello. I spoke with Community Enhancement and Compliance, and they told me that, as reported just now, that the property was in compliance, and they had no idea why we were having a hearing. At that point, I believe the city had shut down all the businesses in this property. This is a commercial property, and not only did they shut them down, but they also have not opened. So there's nobody there, nobody paying rent. This was a time of COVID, and all businesses were closed. This was taken care of as soon as possible. Obviously, it was within, I don't know, whatever the dates are, whatever she just said was done within a week. And it was complied with. This garbage that was there apparently was from people who have nothing to do with the building. They just dumped it there. It was not from any of the tenants because they were closing down their businesses at the time. So essentially, imposing a fine is rather severe hardship, considering that this was in compliance within a very reasonable period of time. I mean, all the cases I've heard so far, nobody was in compliance within 30 days, and people were asking for extensions. This was done under extenuating circumstances, and I don't think any fine should be applied because of what was happening. I mean, the city closed down all businesses.
Can I say something, Your Honor?
Sure, of course.
This citation was issued prior to COVID-19 businesses closing down. This property has had other citations issued to them for this same situation. It has been kind of an ongoing problem for them of their dumpster doors being open, broken, garbage bags and debris inside the dumpster, around the dumpster, on the ground, in the alley. So this occurred prior to the businesses being shut down.
If I may reply to that.
Yes.
First of all, I don't think we're here to talk about other instances, but any and all other instances were complied with and have been handled. I am an absentee owner, number one. So it's not like I live around the corner and I can do something about it. Whenever we get a notice, we deal with it as quickly as possible and as expeditiously as possible. I do not have control over who tries to throw garbage in our dumpster or lays things there where they don't belong. It's as simple as that. I mean, we're not there, and the tenants who are there are under leases where they are responsible for the maintenance of the garbage. If there's an ongoing problem, it's probably with Taco Craft, because when I go by there, they seem to be the messiest of all people. And they were a tenant in the offices at that point, and probably, I'm guessing, that those chairs were theirs because they moved out during that period of time. So I guess they just dumped it right there, and they expected somebody to take it away, which eventually somebody did take it away. But once again, I'm not on the premises. I don't live in Broward, nor am I there. But anytime we get a notice, we deal with it as quickly as possible. And certainly we did in this particular instance.
Okay, sir. What I will tell you is that it's not, unfortunately, an excuse if your tenant violated as opposed to you, because it's ultimately the property owner's responsibility. That's just the way the law is. And apparently this was pre-COVID. And so I'm going to impose the fine.
Well, if I may say one other thing.
So the hearing's ended. Thank you.
Our next case is on page 9. Inspector Bo-Rig Xantis. Case number CE 20020956. Case address 438 Northwest 13th Avenue. Owner Hassan Van Horn, and this is an administrative hearing.
Over, please raise your right hand. Do you solemnly swear and affirm to speak the truth at today's hearing?
Come on. Swan.
Over.
Yes, I do.
Okay. Go ahead.
Good morning, Your Honor. Inspector Xantis, on the behalf of the City of Fort Lauderdale Community Enhancement, case number CE 20020956, property address 438 Northwest 13th Ave. This property was first inspected on February the 27th, 2020 by Senior Inspector Wilson Quintero, and 48 hours was given for the following violation to be complied. Violation 24-7B, the bulk trash that was on the swell of this vacant lot. On March 3rd, 2020, I conducted a re-inspection on the bulk trash was remained on the property as depicted on the photos, then this case was sent to like clearing for city abatement. Another reinspection was conducted on March 14, 2020. The boat trust was removed. At this time, the city is requesting full amount to be imposed.
We're on the first one on page 9.
Yes.
Okay.
Or
All right.
trash. And it's an appeal.
Yes, I understand. Okay, property owners, what would you like to tell me about this?
Yes, hello. We have a lawn service. Can you hear me?
Yes, I hear you.
Okay, we have a lawn service who
I'm listening.
February 25th, that somebody had deposited this debris there on the property. So 1 or 2 days later, that I notified code enforcement that somebody had dumped debris at the front of our property, and they said it would be investigated. My lawn service told me subsequently that the debris had been removed, and we heard nothing further of it since February, March, April, or May. We heard nothing, no correspondence, nothing until June. We received a bill dated June 17th for $240. I responded to the bill in writing stating that we had never received any written notices that we had debris to remove.
Did I lose them?
Need to remove the debris after they investigated. They should have sent me a notice saying they will need to remove it. We have lots in other places like City of Oakland and in Miami, and that's the process we've always gone through there, that they've investigated it and removed it, and I've had no further issues.
Okay, as city inspector, can you address yourself to the notice?
Yes, Your Honor. It is a property owner duties to keep maintaining the property, and then as the property owner mentioned that his lawn guys noticed the violation was on the swell, so he should have removed it. Then this was taken care by the city, and the notice was posted on the property. So notice is posted on the property given 48 hours on the 27th of February for the case to be complied. It wasn't, so then in March, another reinspection was conducted on the property, and the violation remains on the property. Then that's when the case was proceed for the city to abate it. So that right there gave it more than 48 hours for the trash to be taken care of since the February 27th. So at this time, the city went ahead and moved the trash. Then all fine out to be imposed as more than enough time was given for the trash to be removed from the property by the owner.
Okay, I find that notice was given and I'm ruling for the city. Thank you.
Thank you, Your Honor.
Next case.
Our next case is on page 9. Inspector Wanda Aquavela. Case number SE 20020104. Case address 1109 Northeast 18th Court. Owner Zola Martin. This is an administrative hearing.
There we go.
Hi, am I being heard?
Yes. hold
Yes,
on,
I'm
please.
waiting for the inspector.
Hi, Wanda.
Right here. Hi.
Can you raise your right hand? Also, okay. Do you both solemnly swear and affirm to speak the truth at today's hearing?
Yes.
Okay, thank you.
I don't hear anything.
This one is for 1109 Northeast 18th Court.
109 Northeast 18th Court, okay.
There goes the picture.
Hmm.
Can't see the date.
Can we get? No, we don't have our paperwork in front of us, Your Honor. The code department has it, but we cited the property, posted notice. We went back at least 48 hours later and the stuff was still there. We took additional pictures and turned it in to have it removed, and our employee removed it.
Your Honor, may I speak now?
Yes.
Hi, this is Zola Martin. I'm the property owner.
Yes.
I never received any notification. I don't live on the property. It's just, as you can tell from the picture, just a piece of land. I never received any email, any letter indicating that I was being cited. One of the other items I sent as well was I have a lawn service that comes every 2 weeks to take care of, maintain the land. And I would have right away have addressed it. There should have been another one which showed all the bills, the property owner. I never received anything because from what I saw, it appeared to me that there is construction happening right next door to my property that may have been what your inspector was seeing. But because I don't live on the property, and therefore I make about every week I go over there just to check on the property itself. There was no notification that was provided to me so I could deal with the issue.
Okay, unfortunately, it looks from my review of the file that notice was posted on the property, which is allowable under the law. And it gives 48 hours, which the trash wasn't picked up in that time, so it costs the city money to go out there and do that. So I'm gonna fine for the city. And I feel for you that you may not have put it there, but unfortunately, as a property owner, you're responsible for checking and removing things in a timely manner. So I have to fine for the city, but good luck to you.
Sorry, may I say one last thing, Your Honor, please?
Hearing's over, ma'am.
Thank you, Your Honor.
Thank you.
Leave Wanda.
Not responded. 1500 Northwest 5th Place. You haven't responded? No. Thank you, Wanda. There we go.
Okay.
Thank you.
That's it?
Yes. Our next case is on page 5. Inspector DeAngelis Gibson. Case number CE 2007-0963. Case address 1611 Southeast 8th Street. Owner Wendy Sorm. Property posted 8/3/2020. Post at City Hall 8/7/2020.
DeAngelis, can you please raise your right hand? Do you solemnly swear and affirm to speak the truth at today's hearing?
I do.
Thank you, DeAngelis.
Good morning, Your Honor. This is Inspector Gibson, City of Fort Lauderdale Code Enforcement, pertaining case and address as read. Inspections of the property were performed on and cited for the following violations. On January 7th, 2020, case CE 191-20816 was cited for 15-272A, operating a vacation rental without the certificate of compliance. A citation was issued for $200 per day. Citation was mailed to the property owner at the address recorded. Case came into compliance on 1/24/2020 and accrued $2,800 in fines. On March 11th, 2020, case CE 200-30362 was opened in reference to parking violations. Inspector Tarosky conducted an investigation and found no parking violations, but gave a warning for trash cart violation. Additionally, the property manager turnkey and police responded to the location due to the number of visitors present and instructed the visitors to vacate the property. Due to timely compliance, no citations was issued for trash carts and exceeding occupancy. On June 8, 2020, case CE 200-50662 was cited for operating against Broward Emergency Order 20-22. A citation was issued to the property. The property was vacant at the next inspection on June 15, 2020. However, this case remained open for monitoring. The city is requesting the fine be imposed at $15,000 for the irreparable and irreversible nuisance occurring at this property. On June 17th, 2020, a warning citation was issued on case CE 200-60629 for trash carts being roadside after pickup. On June 23rd, 2020, a citation was issued on case CE 200-61008 for parking in the street. Additionally, occupants filming a video in the rear of the property, at which time I informed them a permit would be needed. Fort Lauderdale Marine Patrol also responded to this property. The fine for this citation is $250. On July 19, 2020, a citation was issued for case CE 200-70760 for parking in the street. The fine for this citation is $500. The property has a total of 6 calls for service by the Fort Lauderdale Police Department and numerous complaints by the neighbors. The city is requesting to impose all citation fines and that the certificate of compliance be suspended for 365 days.
Okay, do we have a property owner here?
Yes, I'm here.
Okay.
Where to begin? So first of all, I think all of the complaints have been issued by my neighbor. I have been repeatedly bullied, harassed. He learned of where I was employed, emails there, text messages, committed to putting me out of business. So day one, I do have 2 witnesses that when I'm finished here, I'd like to be able to call that can attest to the same. It's actually made me feel very threatened. He's put cameras and audio on my home, particularly if there are Black friends or Black renters staying there. He calls the police. He's accused me of having thugs there. I find him to be very racist and sexist. He works diligently to try to intimidate me. He is a real estate attorney, and he's certainly on top of all the laws. I will admit that when I moved to Florida, first of all, it was my first home. I was not aware of all of the city violations, such as trash cans. One of the times that my landscapers were there and I was there, they put the waste out like a half an hour before when it was allowed. And he immediately called. And that was, I think, one of the trash can incidences. I see parked cars on the street all the time, including his own. So, and I've also had the case where trash.
Can you please address the violations on the property and the number of times that people were called out? I mean,
Well,
you can't just tell me your neighbor's complaining about you. You need to tell me whether or not you believe the violations occur.
Well, I mean, I don't live there, but my management company has rectified as soon as possible when they get notice of that. And through my Ring device, I sometimes can see too much activity, and then I alert them. And that has happened a couple times. I mean, I'm, I live in Pennsylvania, and so it's hard for me to stay on top of this, especially if, looking at like, trash cans or noise complaints when there were just 3 people sitting outside, having a conversation, but they happen to be Black. I think maybe that's part of the problem. I did not operate short-term rental during COVID. I submitted as evidence to code admin the complete lease and all the facts around that case. That was a 5-week rental, and they felt threatened by the neighbor because they were yelled at and taken pictures of. And so they asked to move. So I also lost out on income, and the property management company, you know, also had to refund a bunch of money. So he's making it impossible to have a business there. And this was meant to be a second home and something that could offset some of my costs, my monthly costs. And I am 100% desiring to be in compliance with the city. But I struggle when some of these things, I mean, he would have called in, you know, operating during COVID suspension, not knowing that I had a lease, which I've produced. I mean, and again, I've got a couple witnesses that can attest to the same. When the management came out just to show a potential leasee the property. So there were 2 cars in the street. That was one of the violations. I have reason to believe he actually put the trash cans out one day because nobody else, the management company didn't. I mean, so, you know, I really do, and I've expressed it even to the city, feel threatened. I've had to turn to a lawyer, an attorney, and get a temporary restraining order. I mean, no other neighbor has complained to me. And moreover, I've reached out like olive branches, like come over. I mean, now at this point, you know, that's not happening. And he's pretty much said there's no how. But I mean, at the end of the day, I want this next door. But perfect legal, it's my right. And the city has affirmed as much that I'm licensed for a vacation rental. And I am. I mean, I don't know what more to do. I mean, he literally has said he's got audio and video, and his goal is to put me out of business. And whenever my witnesses here, Cindy Kane, who is a very good friend of mine and helps me with the property down there and checks on, and the management company, who's experienced issues as well, both of them are on the call, Larry Schimbaum and Cindy Kane. And they can attest to the same. Even my friend got threatening messages, and his wife sent her messages. So, I mean, when you've got eyes on the house 24/7, and he's so committed to getting me out of business when I am law-abiding, practicing, you know, as I continued to learn, I will say I had no idea the degree of restrictions and sensitivity that I need to have for things like parking on the street, or, you know, the trash can, you know, it's got to be within these certain hours. And every time the police has been called, they have not cited me if I'm not wrong, because it's not, you know, they're like, okay, sorry, yeah, we know this neighbor, he calls all the time. Don't worry, just, you know, bring it inside, take it, you know, take it down, just make sure. So, and when there has been an issue, I get my management team, or they get on it right away. Like if there are more people there than there should be, or, I mean, everybody's working really hard to do the right thing by me and by this property. And moreover, we have to get so vigilant now on our screening process that we only like let 4-person families stay there, because we know it's going to be madness, especially if they're Black.
Okay, and City wanna weigh in on her testimony?
This is Inspector Gibson again. First, ma'am, I just want to say that when it comes to vacation rentals, they're held to another standard when it comes to vacation rentals. When she made a comment about her neighbor parking his vehicle on the street, well, the neighbor is allowed to park his vehicle on the street, but vacation rentals, because of the nature of what they are, they're held to a higher accountability, and they're not allowed to park the vehicles on the street.
But in
as
some
far
cases,
as the
vacation rental.
Ma'am, you're not here to argue with him. Please let him finish before you speak.
All of these rules are issued when they get their vacation rental packet. All of these rules are listed. So because of the rules are, I mean, they're held to a different standard. There are things that we just cannot accept when it comes to having a vacation rental in the city. So I'm just saying that I understand some of her concerns, but for the most part, the violations that we go out and see, they're real. I mean, they're violations that we come out. I understand that the neighbor makes the complaint. We get out there and they're having a photo shoot. I mean, and we're in the middle of a COVID and there's an excess of 25 people there. That's an issue. I mean, it's a real issue. I'm observing this issue. I don't know, you know.
Okay.
You're on mute, Wendy. Wendy, you still muted.
Okay. Yeah. So I was saying that I saw that on my Ring device. I saw a lot of people coming in and I saw big speakers. So I immediately called the management company and said, you've got to get out there. That, you know, it's almost like a Trojan horse. You rent it out to people. You don't know that that was in their intentions. They said that they wanted to, you know, lease the place. So I try to get on it as fast as I can. And I think, I'm hoping that Cindy Kane and Larry Schimbaum will raise their hand so that they can join this conversation because they can contribute to it. I mean, again, I didn't put for example, the trash cans. Nobody did. So did the neighbor, just to try to accumulate more offenses? And again, I mean, I hope you guys had a chance to review this. This was a legitimate lease that I in the end lost out on as a revenue generator. So did, you know, taxes for the city for that matter. And they were put out. And they were put out because the neighbor was following them and taking pictures.
Your Honor, may I speak?
State your name, please.
Sure. Larry Schenbaum, real estate broker, listing agent for 1611 Southeast 8th Street.
Okay, you may speak.
Just an incident. I was at the house showing the property with a real estate broker, a family of 5. We were showing the home. We had about 4 cars there at the time of the showing. That there was a knock on the door. I opened up the door and there was an officer handing us a document or a citation for too many vehicles on the property. And I was in shock. I mean, we're just showing the property for a listing and we're getting a warning. It was either a warning or a citation for cars out in front of the property. So it's the neighbor every single time that he sees cars or he sees people, he's calling the city. And I know they have a job to do, but this is a legal licensed vacation rental home. I know the management company that's running it. They're very professional. They keep an eye on these homes. I'm just disappointed that one neighbor who decides he wants to put someone out of business or he wants that city block for himself can just shut down a business that's licensed and complying. So I hope that you'll have, you'll at least look at Miss Sorum's side and perhaps, you know, maybe she has fines for her trash cans. But as far as the other things, I mean, she's complying. She's trying to be as diligent as she can to follow the rules. But I think there's a little overbearingness based on the phone calls of the neighbor. He's the only one complaining that entire block.
Yeah, I understand that, but when a neighbor complains and we go out and check it out and find the violation exists, and I have an inspector to testify that the violation exists, so far I've presented little evidence that the violation did not happen, and that's the problem here.
I can only attest to the lease that was there in place and the client that had to leave the home based on the neighbors filming and taking pictures of them and making them so uncomfortable they left the property. Now, I mean, that's one of the violations there on the list.
Okay.
What do we do about that one?
All right. City attorney, want to weigh in on this?
Portia.
I thought
It's me, Your Honor. It's Portia.
Okay.
So based on D'Angela's, his testimony, this vacation rental has been an issue with us prior to COVID. And while I'm sensitive to the complaints or the relationship between this property owner and the complainant, the reality is that the property has repeatedly been in violation. And based on what I've heard from the property owner, I think that the management company could be a lot more present when it comes to physically checking in guests versus trusting whatever activity is going to occur at the property. And even as it relates to the trash carts, it might be a good idea that the property or property management company have come to the property when people are checking out. I do believe that despite why we're coming, whether it's complaint-based or discovery, the reality is that every time we show up, we do find the property in violation.
Okay, so tell me again what the city is asking for.
We're recommending or requesting your honor a $15,000 citation be imposed and that the certificate of compliance be revoked for 365 days because it has more than 3 violations of the code within the past 12 months.
Okay, and can I hear from Rhonda on the 365 days? What does the code say with regard to suspensions?
And for the record, Rhonda Montoya Hassan with the City Attorney's Office. Your Honor, I have to look that up. I believe we can ask for up to 365 days. So that is staff's recommendation. Your Honor probably could suspend it for a shorter amount of time. And of course, as Your Honor is aware, that would certainly not preclude the property owner from entering into a lease longer than 30 days and lease the property. It would just prevent the property owner from conducting short-term rentals during any time frame that you may suggest, either through the 365 days as staff has requested or some lesser amount up to those amount of days.
Okay, I'm going to, go
May I
ahead.
ask a question? I mean, with all due respect, I recognize the seriousness of all of this. And I would say that management, I've switched management companies because of some of my disappointment with the previous one. I'm justified in the rental during COVID. I assume that was the biggest issue on this list. I am, of course, happy to pay. I get that there's a problem here, but I'd ask for some leniency. $15,000 is a lot, and not being able to rent it. I mean, I'm okay with only long-term rentals, but we're really strict. No parties. You can't have people over. No noise.
Obviously, that's not what's going on. So let me ask you this. If under the suspension, do you understand that you can still rent it, just not short-term rentals?
I do understand that.
Okay, all right. Okay, I am going to, pardon me, I didn't hear that.
So we just leave it at that?
You're agreeing to a 365-day extension, suspension?
With no fine?
What does the city say about that?
Your Honor, we would definitely ask for the imposition of the fine, and if Your Honor maybe wanted to carve out something less than that. But as you will recall, the inspector testified there was a video shoot being conducted on the property during COVID. So again, under the law, under Chapter 162, it allows Your Honor to assess a $15,000 fine for an irreparable violation, such as exactly.
I'm sorry to interrupt if I'm doing so, but that video production had not started. They were bringing.
Okay, I've heard enough. Okay.
Cinda,
I raised my hand. I'm not on yet, but so I am her friend, and I'm also friends with the next door neighbors. Used to be friends with them. I'm telling you, they are harassing her. They send me texts. He and his wife, they say terrible things. They are, I mean, I can't even express how much bullying is going on, how much harassment is going on. And I live in the neighborhood. So I see him do this, call the police on any little thing. And he told me, and he told a friend of mine who's a realtor as well, that he was going to do everything he could to make sure that this did not succeed. Everything that he could to make sure that she did not have a vacation rental. So, I mean, over and over again, and he's a powerful man in our community. So, and he's a real estate attorney. So there's really a lot going on. And I also think he doesn't like women. So, and here we have a successful woman who bought a house next to his, and she wants to, you know, use it as another income and property. I mean, there really is something wrong here. And I have to weigh in because, again, I live in this community. I'm from South Florida. I work at Broward College. I go to First Pres Church, and I see this happening with this man every single time. And he started from day one. And the video, the same thing. I'm also on the ring. And the minute it looked like the video was starting, they called the police and they left. Again, in good faith, how can people know that they're going to do a music video there? No one knew. When they rented it, they said they were a nice family and they just wanted a vacation. But as soon as we saw that equipment come in, Wendy called and had them evicted immediately.
Okay, all right. The problem here is that I realize that this neighbor has become harassing, and I understand the testimony and I sympathize with it. But when investigators go out and find the violations exist, then there's nothing I can do but find the violation exists. I've been given very little in opposition of whether or not the violation existed when they went out there. So I'm going to.
Hard. Small.
I'm not taking any more testimony, okay? I've heard enough. I am going to suspend from short day rentals for 180 days, and I'm gonna assess a fine of $6,000. Next hearing.
Thank you.
Our next case is on page 5, Inspector Patrice Jolly. Case number CE 2007-1243, case address 2810 Northeast 60th Street, owner ES Cavell Corp. This property was posted on 7/30/2020 and posted at City Hall on 8/7/2020.
Patrice, please raise your right hand. Do you solemnly swear and affirm to speak the truth at today's hearing?
Yes.
Thank you.
Good morning, Your Honor. Shelley Ann Grant. Give me one moment, please.
Can you mute her? Hold on. Thank you. Patrice, you can go ahead. Go ahead, Patrice.
All right. Good morning. Patrice Jolly, City of Fort Lauderdale Code Compliance Inspector, presenting case CE 2007-1243 for property located at 2810 Northeast 60th Street. Inspections of the property were performed and cited for the following violations. On February 28th, 2020, the property was cited for 15-272.A, operating without a certificate of compliance from the city. Refer to case CE 2002-1070. On July 11th, 2020, the property was cited by Inspector Malakias for a party that gathering at this location. The property was issued a $250 nuisance violation citation for operating against Broward Emergency Order 20-21. Refer to case CE 2007-0442. On July 23rd, 2020, the property was found to be in violation of 24-27.B relating to the trash carts being left roadside. Contact was made with the property owner and the violation was corrected the same day. On July 25th, 2020, I visited the property and made contact with the tenants. Upon admission, there were approximately 13 people at the residence. I issued a $500 nuisance violation for operating against Broward Emergency Order 20-22. Refer to case CE 2007-1067. Additionally, on July 25th, the property was cited $200 for 15-278.2B, exceeding the maximum occupancy allowed. In addition to the above violations, there were 6 calls to police for service in March 2020. Citations were issued to the tenant representative outlining the steps to come into compliance. Citations were issued and posted on the property. Notices were mailed to property owner listed on BCPA via first-class mail on the following business day. Contact was made with the property owner. A pre-hearing inspection was done on August 11th. The property is still in compliance. The city is requesting to impose all citation fines and the suspension of the vacation rental certificate for 365 days.
Okay, who's representing the property owner?
Hi, good morning. I'm the actual owner, Your Honor, Shelley Ann Grant. I represent the company as well, ESPL Corporation. That is my Airbnb. And similar to the previous case, I have an issue as well with the neighbors. However, I would like to address each citation one by one. As the inspector just said that I am in compliance, and as soon as I got notice as far as the most recent issue, which was the rentals for Broward County had ceased because of COVID again, I wasn't aware of that. I didn't have notice of my email. I didn't get anything regarding that, that Fort Lauderdale, it closed their Airbnb rentals down. I'm an assistant state attorney from Miami, so I'm actually aware of all the Miami updates because we get our emails from even our state attorney's office. So I knew that Miami rentals had shut down for vacation rentals. I was not aware that in Broward, another shutdown happened. So that's the reason I had my Airbnb still up and going. Once I found out that there is no more vacation rentals because of COVID again, I basically have been turning down every single reservation request that I've gotten so far on Airbnb. In addition to that, the trash cans, like he said, I've cured that immediately. The violation for February, I believe I had the property rented to someone else. I'm not sure if it was them that was doing it, or I can't remember if it was me, honestly. I don't believe it was me. However, I've been in compliance with the city. I've done everything I'm supposed to do every time. Just like the last case that was heard, I do have a specific neighbor who literally does not like me. She knows I'm young. I'm only 37 years old. I own that property. I'm an attorney down south, and I'm also, I'm mixed. So I'm Black and Indian. And she is an older female, white female, who literally does not appreciate any type of, I don't want to say I mean, blatantly put, she's racist. She does not like Black people. The last tenant that was there was Black, was a Black American, actually. She flew in from some state, and she had 13 guests there. I wasn't even aware that we had a capacity cap at 10 people. But she's the one that called the police each time. So every single time an Airbnb is going on or a rental is going on, she calls the police, and the police come and they do their warnings, whatever. The last inspector, or not Inspector Jolly, but another inspector before him actually called me and was like, listen, I understand that it's not your fault. Like the kid is nice, whoever, the guy that was renting the property, he said, but this neighbor is the one that keeps calling us out. They went as far as to call Airbnb to get my business shut down. So her goal literally is to shut down my Airbnb and to stop me from receiving funds. It's actually personal. I understand that the violation is there. I can't contest that, but it has been cured. At each time there is a problem and I know about it, I cure it right away, because my job is to uphold the law, not to break the law. And and my parents actually know about it, because when I'm not there at the property, I have my parents go out for me. So my mom is actually present as well, Mrs. Grant, and she can even tell you exactly how this neighbor has been going on, and it's not like we're just negligent or I see something going on and I'm just like, I turn my blind eye. That's not the case at all. And I'd wish for your honor to please do not suspend me. I do not want to suspend for 365 days. As you know, the state does not pay. This is my supplemental income, and I really do need this vacation rental. I'd ask for your honor to please just extend some mercy and grace right now. And understand that this is not me personally trying to break any laws. It is the neighbor that has been watching my property. She wants to shut it down, and she doesn't appreciate that I am of a mixed race, and also I'm young, owning that property in her neighborhood. And my husband's Black. He's a Black man. He's a doctor, and I'm an attorney, and she knows that. So she doesn't like that. And I mean, it sounds very petty right now. I understand that, but literally it's the truth, and that's the reason I'm having so many issues. But as Inspector Jolly said, every time there's an issue back in the day or in the past, I've cured it immediately. That is my job. So I don't know if you want to say anything, Mom. My mom, Mrs. Grant, would like to say something.
Mom sworn in.
Good morning. My name is Jen.
Your mother was not sworn in to speak. So
Yes,
please let-
can you speak her in, please?
Mrs. Grant, do you solemnly swear and affirm to speak the truth at today's hearing?
Absolutely.
Okay, go ahead.
Okay. All right. So each time there are guests coming in,
Ma'am, you need to state your name for the record, please.
Jennifer Grant.
Thank you.
Each time there are guests going to the property, I make sure that I am there to meet with them, to walk them through, to give them details on where to park. The land space is very big. It can hold about 6 to 8 cars. I make sure I do that. I tell them about the garbage. The garbage stays in the garage. My husband would go there after they leave and clear those out. Garbages are not left outside. I don't know who had brought the trash can all the way from the back up there. The tenants that were there claim they did not do it. We have security camera on that property, and I have watched this lady from time to time, this particular neighbor, go to the property, looking through the windows, walking around the building. I don't know what she's checking for. She's not a very nice lady. She does not like, my husband is also a black man, and she does not like him, period. Yeah, because we're Jamaican. She doesn't like- And we are Jamaican. Right. So she has this very bad attitude. She congregates right at the at my Mailbox. driveway, Mhm. right by the mailbox. She came to the property. I was inside. She said, I saw toilet paper and I saw paper towels going in the building. Is this an Airbnb? I said, you already know, you have done your homework. She said, yes. And she walked away from the property. So she said, I'm going to go ahead and make sure that I follow up on this. These were her last words. I don't know what she meant, because we have never been in any issues with people or neighbors or anybody like that before. She continues to come by. Another neighbor, I'll allow him to park the car in our driveway when there is no one there. And he said, all the guests, my guests that comes there are very nice people. He doesn't have a problem with them. I don't know when I leave the property what they do, but I have often looked at the camera in the back to see they're congregating. I see how they operate. And once and twice, we've had to call them and tell them, look, you can't be out there past a certain time. Yeah, I have on there, 10 p.m. is the cutoff. Yeah, is the cutoff. Right. And they are not to do that. Whenever they are leaving, I make sure I go there and I look at everything and I check them out personally. They've never moved in without supervision. They've never moved out without supervision. And that's to ensure no damages are done. No damages and, Correct. and all of that. And they're in compliance. Is done to the property and they are in compliance.
I
So-
appreciate your testimony.
Your Honor, if I may?
Yes, please.
Thank you. Ron, and again, for the record, Ronald Montoya Hassan with the City Attorney's Office. Your Honor, again, just like the last hearing, the issue, the story of racism, which obviously, you know, with my last names, I don't in any way condone, but that's not really the story or the relevant discussion for this hearing. Similarly, you know, a difficult neighbor is not a relevant discussion for this hearing. There may be civil remedies for both property owners vis-a-vis their hateful neighbors, but the inquiry for the magistrate today is whether or not there were violations that existed. That's it. You can have an unreasonable, hateful, racist neighbor call 365 days a year, but if code or police come out to the property, there's either a violation or there's not. As the inspector has indicated, there were citations issued because violations at the property were found. you know, again, the issue of what's required of a short-term rental is provided to the property owner when they first register with the packet of information, as the inspector at the last hearing mentioned to Your Honor. And further, the issue of the property owner not knowing that vacation rentals were shut down is a little difficult for me to comprehend. We don't send out emails. Obviously, she knows as the state attorney, ignorance of the law is no excuse, but it's been all over the news, all over social media. It's one county over. Everyone has known that the not only the governor's orders at some point, but certainly Dade and Broward County orders have been very restrictive due to the severity of the pandemic in both counties. I don't know if the inspector totaled the dollar figure of the citations or if the clerk can do that for Your Honor. And again, like the last hearing, administration is asking up to 360 days, but certainly Your Honor has the ability to suspend the license for a lesser time. And it still, of course, allows the property owner to have a lease on the property for longer than 30 days during any suspension time period. Thank you.
All right. It appears that the fine on the property is $950, which I am going to impose. And I'm going to give 180-day suspension.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Our next case is on page 11. It's a lien reduction. Case number CE 19021762. Case address 468 East Melrose Circle. Owner Jaibolo Inc. in care of Flores Vega.
Isha?
Present to Katrina Jordan. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 468 East Melrose Circle with one case that has been read into the record with a total lien amount of $25,750 and a city direct cost of $464.12. The city is requesting a lien reduction to $2,575.
Okay. Property owner?
Yes.
Okay. Are you in agreement with the city's reduction from 25,750 to 2,575?
Yes, I am.
Okay, thank you very much for your cooperation.
Your Honor, you need to give a time to pay the property owner, a time to pay.
Thank you very much, Andres. 60 days to pay.
I'm gonna, one second, Your Honor.
She went out.
I think she went off.
She left out.
There she goes. She can't hear.
Yes, I'm sorry. I forgot to give you a time in which to pay. So it's 60 days to pay the fine. And if you don't pay it within that 60 days, then it goes up to the original fine. So make sure you do that within the 60 days.
No problem. Thank you so much.
Thank you.
Our next cases are on page 12 and 13. Case number CE 09050380. Case address 501 Northeast 4th Avenue, owner 501 Northeast Holdings LP. Case number CE 15061331. Case address 501 Northeast 4th Avenue, owner 501 Northeast Holdings LP. And on page 13, case number CE 15071820. Case address 501 Northeast 4th Avenue, owner 501 Northeast Holdings LP. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 501 Northeast 4th Avenue with three cases that have been read into the record with a total lien amount of $175,650 and the city's direct cost of $4,518.92. The city is requesting and is in agreement with the applicant offer of $15,000.
Okay, as long as the city and the applicant are both in agreement on the amount, unless anyone has something to say for me, I'm gonna rule 15,000 with 60 days to pay.
Good morning. Yes, we accept.
Okay, thank you very much.
Have a great day. Thank you.
Our next case on page 13, case number CE 180400020, case address 501 Southeast 2nd Street, owner Camden Summit Partnership LP. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 501 Southeast 2nd Street with one case that has to the record with a total lien value of $140,500 and the city's direct cost of $1,056.38. The city is requesting and is in agreement with the applicant offer of $10,000.
Okay, as long as the offer and the city request is for $10,000, I will grant that with 60 days to pay unless someone has anything else to say.
That works for the applicant, Your Honor.
Okay, thank you so much for your patience today.
Thank you.
All right.
Next case is on page 13, case number CE 18121702, case address 904 Southeast 14th Court, owners Alice Kometz and Greg Kometz. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 904 Southeast 14th Court, with one case that has been read into the record with a total lien value of $32,750 and the city's direct cost of $602.12. The city is requesting a lien reduction to $3,275.
Okay, property owner.
Yes, ma'am.
Yes, are you in agreement with the city's reduction from 32,750 to 3,275?
Yes, ma'am.
Okay, thank you so much. And your baby's
Thank
been
you. Thank you.
Okay.
Bye.
60 days to pay, ma'am, 60 days to pay.
Okay. All
Otherwise,
right, will do.
All right, thank you.
Thank you. Bye-bye.
Bye.
Our next case on page 13, case number CE 1904242, case address 1522 Northwest 11th Street, owner Kelsey Roberts. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 1522 Northwest 11th Street with one case that's been read into the record. This property has a total lien value of $8,700 and a total city direct cost of $429.76. And the city is requesting a reduction to $1,305.
Okay, good morning. Please state your name for the record.
Good morning. My name is Kelsey Roberts.
Hi, Ms. Roberts. Are you in agreement with the reduction that the city is requesting from 8,700 to 1,305?
I am. Thank you.
Okay, 60 days to pay. Is that good with you?
Will do. Thank you very much.
Thank you very much.
All right, next case on page 14, case number CE 1812092, case address 2200 Southwest 32nd Terrace, owner Lee Munchin. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 2200 Southwest 32nd Terrace, with one case that has been written to the record with a total lien value of $32,750 and a total city direct cost of $258. The city is requesting a reduction to $3,275.
Okay, property owner?
Hi, Lee Monshine here.
Hi, how are you today?
How are you?
Good. Are you in agreement with a reduction of the lien from 32,750 to $3,275?
Is there any way I could get any less? I'm really struggling. I'm a flight attendant and I'm out of work right now.
Is there any possibility of having any more leniency so I could keep my home?
Okay. Is there a number that you're requesting from me that you think is fair, or do you just want me to use my judgment?
I would like, I mean, I probably could come up with $1,000 right now because I have very little pay coming in. Because I did try to comply with everything as in a timely manner and with the limited resources I had to bring everything into compliance. And I'm trying to stay within the law and try to keep my first home.
Okay, and how much time do you need you think to pay that $1,000 if I rule that way?
I could pay that right away, actually.
You sure? I was gonna suggest, and not to jump in, but for the record, Rana Montoya Hassan with the City Attorney's Office, I would suggest maybe giving 6 months to pay. Would that be helpful?
Yeah, I was thinking about that. Okay, so 6 months to pay $1,000.
Thank you so much.
Oh, you're very welcome.
Thank you. Have a good day.
To you and be well.
You too. Thank you.
Our next is on page 14, case number CE 1809050, case address 2619 Sea Island Drive, owner Grace Eisen and Jeffrey Eisen, Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 2619 Sea Island Drive, with one case that's been read into the record. This property has a total lien value of $13,500 and city direct cost of $751.28. The city is requesting $1,350.
Property owner?
Yes.
Okay. Are you in agreement with the city's reduction in the fine from 13,500 to 1,350?
Yes.
10%.
Thank you very much, Your Honor.
Okay, 60 days to pay, okay with you?
Yes, ma'am.
All right, thank you so much for your patience here today.
Take care.
You too.
Our next case is on page 15. Case number CE 1504236, case address 3209 Northeast 36th Street, number 4B. Owner Patricia Miga and Stephen Miga. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 3209 Northeast 36th Street, number 4B. With one case that's been read into the record, this property has a total lien value of $184,000 and city's direct cost of $1,173.76. And the city is requesting $10,400.
Property owner?
You just dropped out.
Hold on,
Do we wanna?
my screen is doing something.
Okay, he's in. He's coming in now. Okay, here they go.
Can I hear from the property owner? Are you on?
Mega?
Oh, hello.
Okay. Good afternoon.
Good afternoon. We have you now. She just read the case into the record. Did you hear her read the case into the record?
I didn't hear it. No, I'm sorry. Somehow all this time we're watching, waiting and waiting, and it finally comes up and it's like it clicks off. It's like, what happened?
Okay, I'm gonna ask her to reread it into the record then, now that you're with us.
That would be fine.
So I'm Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 3209 Northeast 36th Street, number 4B, with one case that has been read into the record. Total lien amount, $184,000 with city direct cost of $1,173.76. And the city is requesting $10,400.
Okay, do you understand that they've reduced the lien from 184,000 to 10,400? That's like about 6% of it. Are you in the agreement with that?
I understand that, but I have a question for you, if I may ask.
Of course.
Okay. I have documents here, okay, that back in 09 and 2010, we had a deal with Bert Ford. I send you the paperwork over for the same issue, okay, agreeing that everything was okay. A memo came back saying that everything was fine. There was no problem. And then 5 years later, this comes back up and all of a sudden I'm in violation, and I had it from Bert Ford. And let me look here once. His initial, we discussed it. Okay, let's see. Absolutely. Let's see. different. Hold on, let me just look here. I know we gave you all this here, a breakdown on it. Oh, wait. Let me just look it over. Excuse me, please.
That's okay, but I would remind you that we're here for a city code violation, and I don't know what board you're talking about that okayed it.
Yeah, Bert Ford, he was the building inspector back in 2009 and 10, right? So he came out, he looked at the back porch and stuff. He said, everything is fine. He okayed it, right? Then we had 5 years later, okay, some gentleman named Inspector Alejandro said that I was in violation. I said, why did it take 5 years? I mean, Bert Ford was his predecessor, I guess. Bert Ford was the inspector first, and then Alejandro came in back in 2015. And I'm saying to myself, it didn't make no sense. And we even had the association approve everything, so everything was fine. I don't know what happened. I apologize. I'm confused myself.
Yeah, apparently there were hearings and other magistrates that made rulings, and we're here on a reduction, so I can't really revisit all of the facts of the case, but I can try to give you some leniency as it. Okay, I've lost you. Did you mute the sound?
Yes.
You have to unmute yourself.
Okay.
We're back.
Okay, I'm sorry. Yeah, I don't know computers, hon. I'm sorry.
Okay, all right. That's okay. I'm going to reduce the fine to $3,800. How much time would you need to pay that?
I want to pay it right away. I like to get it done.
Okay, 60 days to pay, and you can pay it right away if you like.
Okay, if I pay it right away, can I do it online?
I don't.
You'll be able to.
Yes, probably within 24 hours. You got to give us a chance to download it to the system.
Okay, and who do I contact in order to pay it right away?
Can you give him instructions?
We'll send you an email to the email we have on file for you.
Okay, very good. Hey, I thank you very much. I apologize for this. I'm just confused, but hey, I'm just happy that you were working with us, and I want to thank you very much. You got a tough job. I've been watching this all day long. Better you than me.
Thank you, sir. Be well.
God bless you. Thank you.
Thank you. Our next case is on page 17. Case number CE 1403047. Case address 3110 Southwest 17th Street. Owner Ketia Amari and Ibisium. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 3110 Southwest 17th Street. With one case that's been read into the record. This property has a total lien value of $28,510 and a total city direct cost of $700.46. The city is requesting a lien reduction to $2,815.
Is the property owner with us?
I'm here.
Okay, ma'am.
I'm sorry.
That's
I'm like, oh
no. That's okay.
I was having a heart attack.
I understand. The total lien is at this point is $28,510. The city is willing to reduce that to $2,815, which is about 10%. What is your position on that?
Oh, is it possible that it could be reduced a little lower and I'll pay it right away because it's a little tough?
Okay, I read your record. I know you have 3 kids at home and you lost your job, etc. So what is it you're asking that you think is fair for the fine to be reduced to?
Can I pay whatever the city is holding on for administrative cost?
Okay.
That's 700 something. Can I pay that? And I'll pay it right away. I don't even need 60 days.
Okay. All right. I'm going to reduce to city costs of $700.46, 60 days to pay.
So thank you so very much. But prior to the gentleman, I will receive an an email, detailing how should I pay for it?
Yes,
Yes.
ma'am.
Okay. Oh, thank you so much, guys.
Okay, thank you.
Thank you.
Wow.
Woo. I appreciate that. You guys have a good day.
You too. Our next case is on page 17, case number CE 11081091, case address 2122 Northwest 7th Court, Owner Mutual Income Group. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 2122 Northwest 7th Court, with one case that's been read into the record. This property has a total lien value of $186,600 and a total city direct cost of $509.64. Background for this property: 2122 received a prior lien reduction to $25,000, which the prior property owner failed to pay. The current property owner cleared the city's hard cost of $19,600. Thus, the city is requesting $5,400, which is the difference between the original reduction amount and the hard costs already paid.
Okay, property owner.
Yes, I'm here. Can you hear me?
Yes, yes. Did you hear what the city just recited?
Yes, yes.
All right, so they're at this point willing to reduce the fine to $5,400, which is only 3% of the original lien. Is that acceptable to you?
Sure. I just wanted to just add one thing. When I bought this property, we saved this property from being demolished, and when I did the original budget to do this property to rehab it, there was some extra unforeseen costs because when they started the demolition process. I had to redo the plumbing all over again, and also there was an extra $15,000 that I had paid to set up the water meters because the City of Fort Lauderdale had already disconnected and they couldn't find the water meters. So what I'm asking for, because those costs were unforeseen on my side, was if I can get those costs to offset some of these costs for the lien reduction, and if we could just get this reduced to just the admin costs, I'll greatly appreciate it, because I did end up spending an extra, almost at this point, probably at least another $25,000-$30,000 that was unforeseen because of the unforeseen anticipation of them starting the demo process, and also because of the water meters that wasn't known that at the time when I went. I only found out after we pulled the permits and they had everything, and the city couldn't find the water meters, that I had to actually pay the extra $10,000 to set the water up on the property.
Okay. All right, I'm gonna reduce the fine to $1,800, and I'll give you 6 months to pay.
That's awesome. Thank you very much. I appreciate it.
You're welcome.
Our next case is on page 15. Case number CE 17041292. Case address 217 Southwest 33rd Court, owner 217 BOG LLC. Katrina Jordan, Supervisor for the City of Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 217 Southwest 33rd Court. With one case that's been read into the record, this property has a total lien value of $65,400 and a total city direct cost of $335.32, and the city's requesting $6,540.
Okay, yes. I'd like to address the procedural issue first. It's my understanding that there was no Massey hearing on this. Is there somebody here for the property owner?
I'm here. I'm John.
Okay, all right.
John, your mic is muted.
Yeah, I'm gonna ask the city attorney to, because it looks like I was handed a memo that the city's willing to take administrative costs of $1,275. However, because there was no Massey hearing, that this may have to wait to go through a hearing, or can they waive it? I'm asking the city attorney to weigh in on that.
Thank you, Your Honor. And for the record, Rhonda Montoya Hassan with the City Attorney's Office. I know we've been trying to work with the property owner to get a resolution to this outstanding fine. The property is being sold, and we're trying to assist in that closure of that real estate matter. So it is the city attorney's position that they can waive that, and that we would be supportive of the 1,200, whatever you had just read. I didn't write it down.
75.
Yes, ma'am. So that they can have an amount certain and be able to close on the property.
Okay, can I get on the record from the property owner a waiver of the Massey?
Can you hear me, Your Honor?
Yes, I can.
Your Honor, my clients, Mr. and Mrs. Shambora, are available. We also had a witness, but we waived the Massey hearing.
Okay,
And we will accept the administrative costs of $1,275. And I just want to thank people at the city. Just to correct Ms. Hassan, my clients bought the property back in September of the year before. This had to do with a 10-year certification after 40 years. All of this had been done. My clients are a mom and pop. They put a lot of money in financing. So it's not that they can buy the property. They've closed, but they have an SBA loan that is time critical. So we're very appreciative that we were able to get on this hearing. So Derek and his sister Shambora's, they are available to click in to confirm this, but I'm their lawyer. So we will waive the Massey. We will also agree the administrative costs at $1,275. I just want to mention that Katrina has been very, very helpful, but also Mr. George Oliva, and I submitted that as evidence. Mr. George Oliva, in his email of May 15th, was in accord with this also. So if there's any other questions, I'll be glad to answer. Thank you.
Yeah, the only thing is I'm going to order this $1,275 and 60 days to pay. Is that sufficient?
Yes.
Yes, ma'am.
Okay. All right. Thank you very much. Thanks for your cooperation and your patience here today.
I want to thank everyone at the city for having been so helpful to my the Shamboras.
You're welcome.
The owners. Thank you. Bye-bye.
At this time, if there are any respondents whose cases, for all respondents whose cases have been read, we're now asking that you please log off. If your case has been heard, we're now asking if you would please log off.
Everybody logged off?
Everybody.
Are there cases on the agenda where there have been no respondents show up?
Yes.
Let's see what Adam can, is there a way to talk to him without everybody else?
So are we still being recorded or we're?
Yes.
We are, okay. Let me know when we're off the recording so we can. We have to go through the ones without responding. So
We're not going.
You're not going to?
No, only because some people may not have.
Okay.
So we're gonna just-
Those were the admin hearings, right, Katrina? The ones that some of them did not have respondents?
Not just admin hearings. We've had 2 from lien reduction that had no respondents, and 1 other additional case that did not have a respondent. We were checking the room just to make sure, because some people did not sign in with their legal names, some signed in with a phone number. So we were just trying to make sure that anybody that's left in the waiting room has a case that's been heard. So right now, anybody that's left in the waiting room who says that they have a case that hasn't been heard, we're going to bring them in to see if their case has been heard and maybe they missed it.
Okay, I know I see Mara on the list and she was a part of James Club Recovery.
She spoke.
Yeah, I'm thinking maybe she just didn't log out.
Is there anyone else we see that? Adam Brown.
Hello, Your Honor, and members of the council. How are you?
Good. What case are you here on, sir?
So I'm here for case SE 191-20073, which was a bulk trash violation notice that the property that I manage received, my client, on December 17th, 2019.
What's the address?
On page 10.
1500 Southwest 5th Place.
Okay. All right, do we have,
We need to swear you in. And you need to identify him as well. The only people that's in here now is city staff, so that's fine.
Hi, Adam.
Oh, my name is Nick, actually. I'm on my brother's computer here.
Okay, good morning. We just need to see your ID.
Okay.
Thank you. Could you raise your right hand? Do you swear to affirm to tell the truth at today's proceedings?
I do.
All right, thank you.
So the reason that I'm before you today is because we received a bulk trash violation notice on December 17th, 2019.
1 second, sir. Do I have an inspector to present the case?
Winter or Acapella, Wanda?
Familiar with a Tony Bernard?
Yes, you saw his name on here.
He just logged in.
But then we have Wanda online now.
I don't think hello, Wanda, can you hear us? I don't think she's at the computer.
I didn't know who I put him on hold. Hi, Nicholas.
Hi.
Hi, we're gonna have to place you on hold while we get the inspector back, because this morning, when we checked in, all of the respondents, you had not checked in, and so the inspector was not aware that you were present. So give us a minute, please, and we're going to locate the inspector.
Okay, I apologize for that. Thank you.
No worries, thank you. That's also Wanda. Jeffrey, is that way to pause the meeting for a minute?
Recording.
Can you pause the recording? We're going to pause for 2 minutes while we locate the inspector. Thank you. I'll take this off here. Good afternoon. We're now resuming this morning's virtual special magistrate hearing. For case number SE 20020102, case address 1351 Holly Heights Drive, as well as case on page 10, case number SE 19160073, case address 1500 Southwest 5th Place. Due to the time of sign in, these two cases have to be rescheduled to our next hearing. Our next hearing is on September the 9th. Your cases will be rescheduled to September the 9th. You will receive notice via email, and you must sign in an hour before the meeting starts.
Okay, I can hear you. Okay, so it's pushed to September 9.
Yes.
Okay, great. Anything else I can say?
Not right now, sir, but on September the 9th, you will have a time to state your case before the special magistrate.
Okay, thank you very much.
Just gentlemen, please remember, since it's virtual and we're trying our best, but please try to make sure that you sign in before 9 a.m. so that we know you're here. And then, you'll be in the waiting room and you guys can do whatever you'd like. But, we just need to know everyone's there for the inspectors and for the scheduling. That would be appreciated.
Okay. So from the moment I sign in at 8:30 a.m., then after that, will I get an approximate time or I need to stay on the computer?
You would need to stay on the computer.
That means I have to stay on the computer until my case is heard.
Yes, sir.
Okay, so I need the whole day off for that day, right? September 9th. I have to keep the whole day available. Is that correct?
We don't know, but I would advise you to be prepared to take some time because we don't know exactly when the case will be called.
Okay. If I cannot make it, then the case is dismissed and we have to pay the bill. Okay. All right. I'll explain to my boss and I will see you September 9th.
So just try to sign in early since we take the cases in order that people sign in.
Okay. I appreciate it. Okay. Thank you for your time.
Thank you.
Stay safe. Okay.
You too. Mr. Brown?
Yes, yeah, I understand. I've been watching since the morning, so I must not have signed in correctly. Perhaps I could ask for some more detailed instructions on doing that.
I definitely make sure that you get the full email from the city moderator.
Okay.
Okay, so we'll see you on September 9th. Thank you so much.
Thank you.
Our next case is on page 16. Case number CE 16101768. Case address 1700 Northwest 26th Avenue. Owner Jennifer Scarano. Katrina Jordan, Administrative Supervisor for the City of Fort Lauderdale, presenting property address located at 1700 Northwest 26th Avenue. With one case that's been read into the record. This property has a total lien value of $208,100 and a total city direct cost of $744.92. And the city is requesting $5,205.
Hello, yes. Hello. Can you hear me?
Yes. Are you both going to be speaking?
Yes, I'm sorry. I have.
Jennifer, we can't hear you.
She never signed in.
Can't hear you.
Can you hear me now?
Yes, I can hear you
Okay.
now.
Are you
I'm
both,
sorry about that.
Are you both going to be speaking?
Yes, this is my father and I'm Jennifer Scarano. We have our IDs here. We haven't been sworn in the beginning when we were called to do so. I wasn't able to communicate.
Okay, can we see the IDs, please?
Yes, so here's mine.
Thank you.
Okay, and then this is my father's.
Okay, thank you. Can you both raise your right hand?
Yes.
Do you solemnly swear and affirm to speak the truth at today's hearing?
Yes.
Thank you very much.
You're welcome.
Okay, the city has generously reduced the fine from $208,100 to $5,205. Are you in agreement with that figure, and what do you want to tell me?
Well, so when we first were gonna buy the property, we were not aware of that violation amount. We were only told that the violation amount was gonna be around $30,000. We were not aware that it was gonna be around $200,000 until after I bought the property. And they told us that it was gonna be 10% of that $3,000. So we thought we were only gonna pay around $3,000.
Okay.
And right now, unfortunately, during the COVID-19, I did lose my job, so I am suffering right now with that. So if it could be possible to reduce that amount, I would greatly appreciate it.
Okay, and what do you think you can afford to pay?
I could afford to pay $1,000 right away.
Okay. All right, I'm gonna reduce it to $1,000 with 60 days to pay.
Okay, thank you so much. Thank you for your patience.
We appreciate that.
Have a great day.
You too.
So this concludes our special magistrate hearing for August 13th, 2020.
Thank you. Great to see you guys.
Have a great day.
Great to see you.
You all did a great job, ladies.